Hi everybody, we're on Chapter 14, the USA Patriot Act, Foreign Intelligence and other types of electronic surveillance covered by federal law. Let's start off. You should have already read Chapter 14 and you should have the PowerPoint open and the textbook in front of you. Turn to page 415 of your textbook and let's read about the myths and facts about surveillance. Myths. Search warrants must be obtained when using officers in an undercover investigation. Fact. Based on the Misplaced Reliance Doctrine, search warrants are not required if someone voluntarily allows an undercover officer to observe, record, or participate in criminal activity. Myths. A search warrant is needed before police can look at messages stored on a cell phone. Fact. Many courts have held that officers may scroll through text messages and call logs on a cell phone that is in the possession of a person at the time he or she is arrested. However, right now the Supreme Court is looking at that. And I'm recording this on May 6th, 2014, and this is being reviewed at the Supreme Court right now, so we'll see how that changes in the future, or if it changes. Myths. Wiretaps are only allowed for investigations of organized crime and kidnappings. Fact. The Wiretap Act allows federal officers to obtain wiretap warrants for a long list of crimes. There's state wiretap acts as well. Myths. The USA Patriot Act created a new vehicle for investigating terrorism. Fact. Many of the provisions of the USA Patriot Act amended existing federal laws. A few new statutes were added. Myth. The Patriot Act replaced all existing federal laws regulating the issuance of electronic surveillance warrants. No. Fact. The U.S. Patriot Act amended some portions of the Wiretap Act of 1968, but most of the provisions of the original act are still in place. It also amended the Foreign Intelligence Surveillance Act. Myth. The Foreign Intelligence Surveillance Act of 1978, or FISA, was enacted to exempt the CIA and other U.S. agencies involved in foreign intelligence gathering from the Fourth Amendment. Fact. FISA created a vehicle that enables federal judges to issue electronic surveillance warrants for use by federal agents gathering foreign intelligence and investigating international terrorism. It does not replace the Fourth Amendment. Myth. The President of the United States can authorize wiretaps for foreign intelligence purposes without asking a judge for approval. Although I think that may have happened recently in the news. You may have read or heard about that. Some issues with foreign intelligence surveillance, as well as, we'll talk about that more later, as well as surveillance of U.S. citizens. Fact, the President can order the installation of wiretaps for foreign intelligence purposes, but approval from the Foreign Intelligence Surveillance Court is necessary to continue wiretaps for extended periods. All right, let's dive into this, and let's look at Slide 4, Eavesdropping. The Misplaced Reliance Doctrine. Rather than reading what's on the slide, let's look at page 416 of your textbook. Under Eavesdropping and the Misplaced Reliance Doctrine, second paragraph under that, in situations in which the suspect knew someone was listening, the Supreme Court has placed the burden on the suspect to make sure that he or she can trust everyone who hears what is said. This is called the Misplaced Reliance Doctrine. The person who overhears the conversation may carry tape recorders, transmitters, or other high-tech equipment without prior authorization from a judge. The same rule applies if one party to a conversation allows law enforcement to hide a recording or transmitting equipment on others' premises. Back to Slide 4. There is no need for a warrant if one party consents to a tap or if they are the police. This rule covers both persons and devices. Conversations to be protected need an expectation of privacy. In California, you may or may not know that it's illegal to record private conversations without the other party knowing it. This varies from state to state, unless you're in a public setting. So if you're in a private setting and there's an expectation of privacy, it's illegal to record somebody without them knowing. So that's important to know so you don't break the law there. And different states vary on that. Slide 5, Hoffa versus the United States. The government charged Hoffa, an important union official, with violation of the Taft-Hartley Act. Critical issue was whether government could place on an informant into deliberations on the defendant, even when communications with the defense's lawyers was happening. The court ruled that there was no violation of the Fourth, Fifth, or Sixth Amendment because the conversations were voluntary. Look on page 417 on your own and see examples of the misplaced Reliance Doctrine. And let's turn to slide 7, electronic surveillance. Originally, cases focused on trespass issues. Did the police have to trespass in order to place a tap? Wiretaps on public phones required no warrant. Gradually, those standards were changed by courts, and the key became an expectation of privacy, not the location of the conversation. Eventually, statutes were passed to regulate the procedure. Page 419 of your textbook, all the way at the bottom, warrant requirement for electronic surveillance defined. An electronic surveillance warrant is required to install wiretaps and electronic listening devices that invade a person's reasonable expectation of privacy. The warrant must contain a detailed statement of probable cause, including a showing of why other investigative techniques will not work. The warrant must not permit electronic monitoring for extended periods of time. Slide 8, Katz versus the United States. Katz used a payphone to operate an illegal gambling scheme. The police recorded the phone conversations without a warrant. The Supreme Court excluded the tapes. People with a reasonable expectation of privacy in their conversations are protected by the Fourth Amendment. This case overruled past decisions like Olmstead versus the United States that relied more on the concept of trespass. Look on your own on page 420. Actually, you know what? I'll look with you. Let's go to page 420 of the textbook at the bottom. Let's talk about PIN registers, trap and trace devices. All the way at the bottom, PIN registers. They record the numbers dialed for outgoing phone calls. That's common to gather those for narcotics investigations or homicide investigations, especially narcotics, though. Trap and trace devices, they record the phone numbers on incoming calls, much like a caller ID. Neither is covered by the Fourth Amendment or the Wiretap Act because these devices do not seize or record conversations. They just gather the numbers. Halfway down, the legislation mandates that a court order be obtained before installing PIN registers and trap and trace devices. Last couple sentences of that paragraph. Note that it is not necessary to establish probable cause. The court order is valid for a maximum of 60 days and can be extended for an additional 60 days. Top of page 421. Actually, no, we're not going to look at that quite yet. Let's look at slide 10. I kind of read ahead. Slide 10, Electronic Surveillance and Wiretap Act of 1968. What is not covered? Consensual taps, PIN registers, trap and trace. We already read about that. Calls where no expectation of privacy, such as from a prison. 85% of warrants were for drug cases. 98% were to tap cell phones. Okay, let's go back to page 421 now. At the top of page 421, the same procedure that is used to obtain the original court order must be used to obtain an extension. If it is essential to act immediately, a PIN register or trap and trace device can be installed before obtaining judicial authorization. To qualify, there must be an emergency involving A, immediate danger of death or serious bodily injury to a person, B, conspiratorial activities characteristic of organized crime, C, an immediate threat to a national security interest, or D, an ongoing attack on a protected computer, such as defined in 18 U.S.C. Section 1030. Next paragraph. The Fourth Amendment does not apply to transponders, also called bumper beepers, as long as they do not enter residences. Next paragraph. A 2012 Supreme Court case cast doubt on earlier ruling on transponders. This case involved the installation of a GPS tracking device on the undercarriage of a vehicle while it was in a public parking lot. The vehicle's movements were tracked for 28 days. Information was automatically uploaded by cellular phone to a government computer. The Supreme Court held that the installation of a GPS device on a vehicle and its use to monitor the vehicle's movements is a search because the government physically occupied private property for the purpose of obtaining information. As a result of this ruling, a search warrant is required in order to install a GPS device, even when the installation is done in a public parking lot. What time do I have? Okay. Slide 11, Electronic Surveillance and Wiretap Act of 1968 continued. The Wiretap Act, it's a felony to place an illegal tap. It covers writing, sound, image, and data. Illegally gathered evidence is not admissible. Under the Patriot Act, an extended coverage to more types of communication like email and voicemail was included, and it loosened some of the standards.